having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's special history series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Good evening and welcome to C-SPAN's Landmark Cases. Tonight's case is Tinker versus Des Moines Independent Community School District. In this 1969 case, the Warren Court, in a 7-2 decision, ruled that students' First Amendment rights to free speech are still protected even when they're at school. For the next 90 minutes, we'll learn more about the history of this case and its significance in our society today, in a year when there are lots of students voicing their opinion on issues around the country. Let me introduce our two guests at the table. Mary Beth Tinker is one of the namesakes in the case. She and her brother were students in 1969 when this case came to the court, and she'll be here to share her personal experience and her work as an adult now to promote student free speech and student press freedom. Thanks for being with us. Nice to meet you.
Thank you. It's good to be here.
Eric Jaffe is the chairman of the Federalist Society's Free Speech and Election Law Practice Group. He's been involved in more than 100 cases before the Supreme Court and clerked at one point for Justice Clarence Thomas. Thanks for being our guest tonight.
You're welcome.
So, in a nutshell, when you tell young people what this case is all about, what's the headline on it? What do you say?
The case grew out of the civil rights movement, really, but in the end, we wore black armbands to school to mourn for the dead in Vietnam in 1965 and to support a Christmas truce that was being called for by Senator Robert Kennedy. And for doing that, we were suspended. The American Civil Liberties Union took the case all the way to the Supreme Court, which ruled in 1969 that neither teachers or students leave their First Amendment rights at the schoolhouse gate.
So you've spent a career in First Amendment issues. Why is this particular case important?
Well, I think it's important less for what the specific holding and the details of that holding were than for the great rhetoric and language and aspirational nature of the case. It really sort of signals what the First Amendment's about and says young people are not left out of that principle, even if there may be some issues on the margin on how to apply it to them. But I think it at least gives young people something to aim for and to aspire for and to strive for.
We will have 90 minutes at the table, and we're going to learn about the court at that time, what the arguments were by the lawyers on both sides, what the decision was, and what that impact is. And in about 15, 20 minutes, we'll start taking telephone calls and questions by Twitter. I'm going to give you the phone numbers now so you can get in queue, and we hope you'll be part of our discussion. If you live in the Eastern or Central time zones, 202-748-8901. Mountain and Pacific time zones, 202-748-8902. If you tweet us at C-SPAN, use the hashtag, please, Landmark Cases. Well, let's first start with the fundamentals. This is a First Amendment case. So a quick review of the First Amendment of the Bill of Rights. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. In the Tinker case, is a particular clause in the First Amendment that is pertinent, particularly pertinent?
Well, indirectly, yes. So no law abridging the freedom of speech. Tinker would clearly fall under the category of freedom of speech. In the particular instance, it was symbolic speech, but the court had already recognized that symbols can convey meaning and argument much as words can. But it was actually the 14th Amendment that applied to the school district, not the first. The 14th Amendment, which incorporated the First Amendment as against the states, because, of course, the First Amendment talks about Congress, but the 14th Amendment applies to the states, and the basic principles of the First Amendment commutatively apply to the states as well now.
With regard to schools, before this case came to the court, what was either the law or the custom?
Well, there had been the occasional case that upheld sort of student rights, if you will, or at least applied things to schools. So the Barnett case about having to stand for the Pledge of Allegiance if you had an objection, though one might think of that as a religious case as much as a speech case. But in general, schools had a lot of leeway, tons of leeway to restrict kids and to maintain discipline and to do what they wanted. And if you look at someone, Justice Black's opinion, for example, or later opinions by other justices, schools had almost the role of a parent to the children. such that they could do what a parent could do and tell them to stop talking or whatever they wanted.
So, Mary Beth Tinker, the backdrop of this was you and your brother and fellow students' protests of the Vietnam War. In 1965, do you remember what you were concerned about? What was happening in 65 that brought this to the attention of you as young people?
Yes, I remember very well that, as I said, it really grew out of the Civil Rights Movement in many ways, because right now, today, April 23rd, we're celebrating the 67th anniversary of a school walkout in Moton School in Virginia, where Barbara Johns and her fellow students, around 400 students, walked out of school in 1951. And then after that, of course, you had the Brown decision in 1954, and the Little Rock Nine was in 1957, and then the Birmingham children with the Birmingham Children's Crusade was in 1963, when almost 2,000 kids marched and rallied and were arrested while Martin Luther King was in jail, writing his famous letter from Birmingham jail. And so all of this was very inspiring to us kids who were following this in the news. And so by 1965, well, in 1964, something very important happened also involving young people, and that was when Cheney, Schwerner, and Goodman were murdered by the Ku Klux Klan. And they were part of a movement there of students in Mississippi. The very same day that the students' bodies were discovered, August 4th, 1964, off the Gulf of Vietnam, in the Gulf of Tonkin, a U.S. Navy ship claimed that it had been attacked. And as it turns out, it likely had not been attacked, but it did not stop the U.S. Congress then from voting almost unanimously to start escalating even more than they were the Vietnam War. So by 1965, there was still plenty going on with the Civil Rights Movement, Selma, and so much more, but now on the news we saw war, the Vietnam War all the time, the soldiers, the children running from their huts, the body bags, Walter Cronkite announcing, the body count today in Vietnam was 10, and day after day we were hearing that by 1965.
In fact, in 1965, the numbers were 184,314 U.S. soldiers on the ground fighting the war, and that year, 1,912 deaths alone in Vietnam. And we're going to show you a little bit for all the young people in our audience, and we hope there are lots of you watching tonight in this student free speech case. We're going to show you a bit of a universal newsreel, which is the way many people got their news back then, talking about some of the protests that were starting to erupt around the country as the war progressed.
Anti-war demonstrators protest U.S. involvement in the Vietnam War in mass marches, rallies, and demonstrations. Central Park is the starting point for the parade to the UN building. The estimated 125,000 Manhattan marchers include students, housewives, beatnik poets, doctors, businessmen, teachers, priests, and nuns. Makeup and costumes were bizarre. Before the parade, mass draft card burning was urged. Demonstrators claimed 200 cards were burned, but no accurate count could be determined. Reporters and onlookers were jostled away on purpose. Although mostly peaceful, shouted confrontations were frequent and fiery during the course of the march. The anti-war marchers were picketed by anti-war marchers who were hawkish toward the parading doves.
And that's just a bit of what was happening domestically in the United States as the war continued to escalate abroad. So with this backdrop, the students in Des Moines decided to express their opinion. We're going to tell you a little bit about how that happened and who the characters were involved. And to learn more about it, it was yourself, your brother John, and Christopher Eckhart who were the defendants in this case. Tell me about you, your brother, and Christopher, how you all came together.
There was a group of students at Roosevelt High School, and after the march in Washington, some of the students had been there. When they got back to Des Moines, the students had a meeting, and there were some college students and some adults there also, and they talked about what they could do in Des Moines to, speak up about the war. In 1963, when the children in Birmingham had been murdered by the Ku Klux Klan in the big bombing, James Baldwin sent out a letter along with Bayard Rustin, who was a leader in the civil rights, saying we should all wear black armbands to mourn for the dead children. For Carol, Addie Mae, Denise, there were 4 girls who were killed there and 2 boys actually later on. And so that's what happened around the country. People wore black armbands like this after the children were killed in Birmingham in 1963. I was 10 years old. So in 1965, then when the war was building up, there was a suggestion, what about black armbands? And wearing those to mourn for the dead. The black armband was a symbol of mourning that went back through history for many, many, many years. And it was a symbol of sadness, and we were all feeling very sad that Christmas about the war. And so that's how the idea
What did your parents think of your protest? Did they know about it as it was developing?
My father was a Methodist minister, and there was a favorite prayer in our house, which was, Lord, make me an instrument of thy peace. And where there is hatred, let me sow love. And so that was the way that I was brought up to, try to make a more peaceful world and a more just world also. And then later he became involved with the Quakers, and our whole family became more involved with the Quakers. And so my dad didn't want us to wear the armbands necessarily because he said, the principals have a job to do too, and it's not so easy. But my mother understood more, and so the students in the Unitarian Church and the Quaker meetings started talking more, and they heard about this idea about the black armbands, and so that's how the idea came to be.
What can you tell us about the school board at the time, or the administration of your school, to help set the context for this?
The principals heard about the idea, and they had a meeting and decided that that would not be allowed to wear black armbands to school. The president of the school board, Ora Niffenegger, was quoted in the Des Moines Register saying that our government has made a policy about Vietnam, and we must follow it. Well, as I explained to students now in the schools, that's not how democracy works. And we do have a right to criticize the government, and actually that's how the First Amendment evolved through the years, was around war and criticizing the government around war.
In addition to the Tinkers and the school board, the other principals in this case will be the Chief Justice Earl Warren and Justice Abe Fortas, who was assigned to write the opinion. As we get started here, what should people know in a big sense about these two justices?
Well, for the Chief Justice Warren, people should know that he was actually a Republican appointed by Eisenhower, but turned out to be one of the sort of more iconic, more liberal justices, and certainly Chief Justices ever to serve on the bench, who is responsible, directly or indirectly, for some of the most iconic decisions this country's seen. Brown versus Board of Ed, New York Times versus Sullivan, Griswold versus Connecticut, Tinker, of course, and many others. So really, he's played an outsized role, much criticized by some, much applauded by others. As for Justice Abe Fortas, I guess what's interesting to know is while he had a fairly short tenure on the court, one of the things that distinguished him was his sort of advocacy for children, oddly enough. This is one good case, but there are others in the criminal context where he really fought quite hard to get certain procedural rights and certain criminal procedural rights applied to kids who were otherwise treated as wards of the state and really not given very many rights at all. And so it was notable. He was an ally of the Chief Justices, but also had a special place in his heart for kids' rights.
We had a chance to speak with your brother to get some of his perspectives on this story before we watch our first clip of that. Let's go to December 16th, 1965, the day the protest happened. Walk us through that day.
1965, December 16th. Well, 2 days earlier, the Des Moines Register had come out with an article, a headline saying that the armbands would be not allowed in the Des Moines schools. And so, of course, I was very, very nervous because I was a shy kid anyway, and I was only 13 years old and in 8th grade. And so people were talking about what to do and what to do, but I decided to go ahead and try to be brave like the other kids that I had seen as examples on the news and things. And so I had an armband, and I just had it on, and I picked up my friend Connie, as I usually did on my way to school, and she said, you better take that off and you're going to get in trouble. And so then when I got to school, I saw one of my favorite teachers, Mr. Moberly, after lunch, and he gave me a pink pass, And I went to the office, and I looked around the office, and I looked at Mrs. Tanner and the vice principal, and they said to take off the armband because it's against the rules. So as I tell the students in the schools now, in a great stand of courage and conviction, I said, okay. And I took off that armband and I gave it to them. But I learned a very important lesson then. You don't have to be the most courageous person in the world. You can be you. You can be scared. You can be shy. And you can still make a difference because that's what happened.
Well, let's listen to Mary Beth Tinker's brother, John, tell some of his story about the protest.
I was getting ready to leave the house, and I didn't want to wear it on the street. I was a little concerned for my safety. And as I was walking out the door, my dad said, you know, John, I'm not sure you should do that. He said, the school authorities, they think that they need to not permit it, and they have a hard job to do. And I'm just not so sure you should wear it and break that rule that they've made. And I said, well, Dad, this is just a black piece of cloth, and people are dying every day in Vietnam. And he said, well, then it's a matter of conscience for you. And I said, I guess it is. And he said, well, then I support what you're doing. Then I walked to school. I went to lunch and sat at the usual table with my usual group of friends, and some kids came over and started pestering me, just like, oh, commie, coward, pinko, that kind of thing. And then this football player that I knew who he was, but we weren't really friends. But he came up and he looked at the kids and he said he saw what was going on, and he said to the kids, he said, look, you've got your opinion about the war. John has his opinion about the war. John has a right to his opinion. Leave him alone. I'm thinking, great. The phone rang, and the teacher, Mr. Laurie, answered the phone, and then he looked at me and he said, they said, send John Tinker to the office. So I spoke with the principal, Don Wetter, and I explained to him why I was wearing it and why I thought the war was wrong. He said, you know, I'm gonna ask you to take that armband off, and if you take it off, you go back to class, it's going to be just like nothing happened. And he said, but I don't think you're going to take it off, are you? And I said, no, I'm not. He said, well, then I'm going to have to call your dad, send you home.
So pick up the story from there. You took your armband off, John left his on, your father was called. What happened next?
Well, Chris Eckhart was suspended the same day that I was. 5 students were suspended from a district of about 18,000 students. And so then some people started getting very mad at me. I got suspended also because the girl's advisor said, well, there was a rule against armbands, so even though you took off your armband, you're going to be suspended anyway. So she gave me my suspension notice, and I went home, and people were talking and trying to figure out what to do. It's really a story of journalism also, because we learned what was going on through the newspapers, and they covered it very fairly and very well also. But some people started getting very mad at that point, and some of the other kids who had been planning the event, like Bruce Clark, Chris Singer, also got suspended. And so then the haters started coming out of the woodwork, and some people threw red paint at our house, and they started sending us mail, hate mail, and saying that they were going to hurt my father, and that was probably the hardest thing of the whole experience, really.
Here's an example of one piece of mail that came to the family. I'm going to turn it over here right on camera. And what was the reaction in your household? Were you all anxious or be calm about it?
Yes, we were anxious, but again, we had the example of all of these kids in Mississippi and Alabama who had been, bombed and threatened, and some of them even killed. And so we kept thinking, well, compared to that, this isn't so bad. At least our house isn't being blown up. At least they're just, throwing red paint at us. And And they would call us communists, and my mom would always say, we're not communists, we're Methodists. So we just got through it. The bravery of our parents and their calm nature helped so much.
When was the decision made to appeal it to the school board?
Well, besides the people that were getting very, very mad at us, there were also supporters. And one of them was a Marine corporal who sent a letter to the editor. I think his name was Harry Corey. And then, of course, the other group that was very supportive was the American Civil Liberties Union. And as I found out later, they go to the Supreme Court more than any organization in the United States. And so one of their members in Iowa named Louise Noun heard about the story, and she just didn't think it was fair. And so she talked to the other members, and they decided to come and help us. And so, of course, the ACLU said, now first you have to try to negotiate. And they always try to help people negotiate without going to court. And so that's what we did. We went back to the school board and had a big meeting, and hundreds of people came, but the school board would not change their mind.
And we have a headline from the time that was a 5-2 vote divided over the issue about student rights. So I'm going to put on screen the key dates in the case so you can see how it progressed through the process of appeal. The school board 5-2 vote was January 4th, 1966. Remember, the protest had been just in December, late December of 65. And then July 25th of that same year, it went to the U.S. District Court to hear the case, and by September 1st of 1956, the complaint was dismissed by the District Court. I'm going to turn to you to ask about process. How does it get from the school board to a U.S. court?
Well, if somebody files a complaint, obviously, in this case the ACLU, files a complaint in the court, and then typically either side makes a motion.
And it was at the federal level because it was a First Amendment case?
Because it was it was an alleged violation of the Constitution, and there's a statute that would allow for those kinds of cases to be brought in federal court, regardless of the amount of money at stake. And so it gets to go to federal court. It's called federal question jurisdiction. Goes to the judge makes a decision. I imagine in this case there was some evidence introduced, there was a variety of steps in between, but long story short, the judge makes a decision, writes an opinion, and then people get to appeal, because the first decision is just the first decision. And
then, in fact, it was appealed to the Eighth Circuit Court, which affirmed it. So walk us through that process.
So the Eighth Circuit, interestingly enough, affirms it 4-4. So they had 8 judges on the Circuit Court hearing the case. These days, normally you would get 3, or in some cases called, you get a larger panel of the court. When you have an even number, you always risk it being a tie vote. And in the law, generally, a tie goes to the judge below. It's sort of out of respect for the judge who made the first decision. If you can't get a majority to say you're wrong, we'll leave your position intact. Same thing is true at the Supreme Court. If you remember when they were one justice down, if they tied, the lower court decision stayed intact. And that's what happened here.
So then how did it go from that to the Supreme Court?
Well, then somebody has to decide to ask the Supreme Court to take the case. So in cases like this, the Supreme Court is not obliged to take the case. You make a request, a petition basically, and say, would you please take my case? It's important, et cetera, et cetera. And the court has discretion to take it or not. But in the Warren era, the court took a lot of cases. Today, this case might not have been taken. A 4-4 decision by a lower court might have been enough to stop this case from being taken. They would have waited for a different case. The issue might have been important, but they would have waited for a different case that presented it perhaps more definitively by the intermediate court. But here they took it because it was important.
While all this was going on in the legal aspect, we're going to return to John Tinker to tell us a little bit more about the reaction in the community of Des Moines where the Tinkers lived.
We got hate mail. Someone sent a homemade postcard with a hammer and sickle on it, accusing us of being communists. Somebody threw red paint on the street outside in front of our house. And somebody else, or somebody, I guess, I don't know, if maybe it was the same person, threw a brick through the front of our Volkswagen, our little Volkswagen Bug. One morning, my sister Mary Beth answered the phone, and somebody said, a woman told her, "I'm going to kill you." There was a talk show host that did a late night talk show here in Des Moines, and he offered on his show to lend a gun. This talk show host also had his own gun shop, and he offered to lend a gun to anyone who would shoot my dad.
So it's John Tinker talking about the stress and pressure on the Tinker family and others who supported them in the community as this case began to work its way through the courts. We're going to go to phone calls and get people involved in the conversation. Our first call is from Glenn in Freeland, Michigan. Glenn, you're on the air. Welcome.
Thank you all very much. Very interesting show. And we've actually had a kind of student rights, free speech controversy in this local area in a town called Auburn, Michigan, just recently over the Confederate flag of all things. So anyway, my question, though, is about academic work. I was thinking that of a time a while back when some Holocaust deniers were creating a lot of controversy over whether they could take ads out in college newspapers. I was wondering if a student, for example, had a controversial opinion like the Holocaust is a big lie, for example, which is obviously ridiculous to most people. If they actually believed this and wanted to write a paper or whatever in a history class or what have you, would they have the right to do something like that? Or would the school administration be able to deny them doing something like that because it's an established fact and all that, and it's just ridiculous? Or would they have, under the First Amendment, the free speech right on a controversial subject like that?
Thanks, Eric. Eric Jaffe, I'm going to ask you to talk about it because it's an academic paper, as the caller's posing the question. So what's the rule?
So the way the rule has evolved lately is that if it's part of the curriculum, the school actually has a decent amount of control over it. So if the school, for example, said, I want you to write about the 60s, and the kid said, I'd rather write about the Holocaust, the answer is no. You've got to write about the 60s. If the school asked you to write about the Holocaust and you had an opinion that said it was lousy, you might well have a right to write that. You just might get a terrible grade. There's nothing that says you have to get a good grade for making bad arguments. It really would depend. But overall, the overall answer is that when it's dealing with curricular aspects of the school has a lot of control.
Well, we're talking about the family story. Mary Beth Tinker on Twitter, Wild and Wonderful asked, did this episode cause a backlash against your father in his parish?
Well, my father by that time was working for the Quakers with the American Friends Service Committee, but it did cause a backlash against my father in town among some people, definitely. And could I just add, by the way, with the last caller who was saying that they had a controversy around the Confederate flag, just to be clear also, the Confederate flag controversies around the country, the courts have ruled fairly consistently against Confederate flags in school. I think one of the cases was in 2013, a recent one in Virginia, I believe, but those have been pretty much, not allowed in schools according to the courts.
Next is a call from Charleston, South Carolina, a student there named Hanan. Welcome.
Hi, I have a two-part question. To my first question, I was wondering if you could please differentiate Tinker from the previously held O'Brien standard, and if you could also differentiate those standards from the particularized message test held in Spence v. Washington in 1974. And to my second part, if there were to be a case coming before the Supreme Court today in which the plaintiff were a high school student and they were disciplined by their high school from participating in the March for Our Lives, what kind of test do you think the Supreme Court today would hold? Do you think they would look at the Tinker test and apply the particularized message test in Spence? Do you think they would defer to O'Brien? Or do you think the court would come up with a new test? Thank you so much.
To clarify, are you talking about the O'Brien the draft?
Draft card burning.
Yes.
The draft card burning or the draft card burning?
Yes, ma'am.
Or the sign against the draft card burning. Well, that had to do with, first of all, they ruled against draft card burning. And that was an adult, and it was also outside of school. So it was a little bit different. Now, if a case got to the court today about walkouts, it depends what would happen. I mean, I did ask Justice Alito when they featured the Tinker case at the Supreme Court Historical Society a few years ago. The Liberty Institute hosted a program there about Tinker, and Justice Alito was there, and I had a chance to ask him what he would say about the Tinker ruling today and would he stand behind it, which he said, yes, I guess I would stand behind it if it came to the court today. Now, walkouts, because of the Tinker ruling, which says that there are two things that students cannot do in schools and to be covered by the First Amendment. One is substantially disrupt school, and one is to impinge on the rights of others. So that is fairly clear. Of course, a lot of schools are deciding, well, we're still going to work with our students and we're not going to punish them for walkouts, even though theoretically, legally, they would be able to.
I think that's probably right. As long as it wasn't based upon, we don't like this view, but you can walk out for a different view. It wasn't viewpoint based. If it was just about you're absent, so you're going to get treated as if you're absent, and that will have the consequences it has. Or if you literally got up in the middle of class and walked out, I think one could view that as disruptive. So you're right, that probably doesn't get a lot of protection. The O'Brien test, I don't think would really apply. I think it would be a straight application of Tinker. And the only time you'd worry about the message is if there was some indication that the school was discriminating against one viewpoint instead of another.
Steve is up next in our conversation about Tinker versus Des Moines, 1969. And Steve's in Salem, Wisconsin. Hi.
Hi, and good evening. This is a question for both Mary Beth and for Mr. Jaffe. I teach at a university here in Wisconsin. I also serve on a school board. And I teach undergraduates who want to be teachers, also graduate students who want to be school principals. So my question is, how do we find that balance between making sure students maintain their freedom of speech and expression and yet ensure the safety of all students without any substantial or material disruption?
Well, that is always the question, and thank you for calling it. The question is always how to balance the rights of all of us, because we live in a society with many, many members with different needs. And there's this concept of the common good that goes back even to Greece. And so all rights have limits. The First Amendment has limits also. You can't go out in the middle of a busy street and say, I'm going to assemble tonight, because other people want to use that street. And this is an issue that's coming up today a lot with the gun laws and the Second Amendment issue, because sure, you have a right to the Second Amendment, but all rights have limits, because the students are saying, fine, but we want to live. We want to go to school without worrying about being shot. And so that is always the question. I'm glad that you raised that. And we have to grapple with that all the time. My own opinion is that students should have some say in how to find the solution to these problems and to these balancing issues.
What would you say to those teachers in training?
Well, as a normative matter of what should you do, I fully agree that you should take student input into account. I would lean towards free speech as opposed to not. As a legal question, at a minimum, what you should do is make sure that if you think there's going to be a substantial disruption, that that's actually true, that there's actually some evidence of that. We so often fear something's going to happen without any real basis for knowing it's going to happen or predicting it's going to happen. And that kind of speculation I would advise teachers and principals to avoid, and really make sure that if they're worried about school discipline and school safety, that it's based on data and real facts rather than passive fear.
Gordon is in Fort Madison, Iowa. Hi, Gordon.
Yes, thank you for taking my call. I wanted to tell just a little story. I was in law school in Des Moines, Iowa in, I believe, 1973. And the famous criminal defense lawyer William Kunstler was speaking, and John, Mary Beth's brother, attended that, and William Kunstler treated him as a great, great hero, and of course we all clapped when we found out that Mr. Tinker was in attendance and hearing Attorney Kunstler speak. And I was just wondering with Mary, Did John ever make it through law school? I think I was a year or two ahead of him, and just wondered what John was doing now.
John didn't go to law school, and I think my brother Leonard was also interested in law school, but he didn't go to law school either. But we've certainly taken a great interest in the law through the years because of this issue and so many others. Thank you for calling.
How many Tinker children are there?
There are 6 Tinker children, and all of them were involved in the Tinker actions. Even Hope in 5th grade wore an armband to Madison Elementary School, and Paul in 2nd grade did as well. And they said that they want peace also, and so we had a great experience a few years ago going back to their elementary schools to celebrate 50 years, and we even met one of Hope's teachers there, Linda Ordway, who had been there at the time.
So with the help of the ACLU, this court, there was a petition made to the Supreme Court. So next we're going to learn about what the court was like in 1969. First of all, why did it take so long for the case to get to the court?
Well, because it takes a while to write opinions. It takes a while to brief cases. So, it always takes a little while. And the court was quite busy back then, I have to say. They have more cases than they have today, certainly. So that's all. It's the normal course. It's not that surprising a lag if you think about starting to finishing a case.
So here's what the court looked like in 1969. We have said the Chief Justice was Earl Warren, appointed by Eisenhower, and the other Eisenhower appointees on the court then, John Marshall Harlan II, William Brennan, and Potter Stewart. Roosevelt appointees still on the court, Hugo Black and William O. Douglas. Kennedy, Brian Whizzer White, and Johnson appointee Thurgood Marshall and Abe Fortas. Overall, what should we know about this court as it's beginning to think about this case?
Well, overall, this was, I think, regularly viewed as one of the most liberal, for lack of a better word. It's not a great word, really, but for most liberal courts in that they expanded individual rights, they expanded federal power, they expanded judicial power in lots of different ways. Now, they're responsible for some of the most iconic decisions in recent memory, but also frequently some of the most criticized. But the majority, led by Chief Justice Earl Warren and a bunch of the later appointees, including Marshall and Fortas and Brennan, of course, really were quite powerful in terms of what they did in terms of transforming American law.
The court heard the case on November 12, 1968. What were you doing that day?
I don't know exactly, but I know that 1968 was a very, very big year for the Vietnam War, and it was one of the worst years in the war. Actually, I do know what we went to St. Louis for the appeals court case, but I don't know. It was hard to be very happy about all of the proceedings and everything because of the war. It was just really taking up a lot of our feelings and a lot of our thoughts, and there was so much going on, of course, with civil rights and just so much.
Did anyone from your family go to the Supreme Court when it was heard?
Yes, we did go to the Supreme Court. I went, and my parents went, and John wanted to go, and he tried to go, but he missed the plane. Chris Eckhart also went.
What was that like?
Well, it's hard for me to remember a whole lot about it because we had just moved to a new city, St. Louis, which was a big city to me compared to Des Moines. And so I was trying to adjust to a new high school, and it was November when we moved there in the middle of 11th grade. So when we went to the Supreme Court right around that time, I was very taken up with other issues having to do with sort of teenage years, who I was going to spend time with, who I was going to be friends with in class and things like that. So I can barely remember the Supreme Court being there, and certainly not very many details about it.
So would you talk to us about the role of the ACLU by the time the case gets presented to the court? What do they do in this process?
Well, the main thing you do once a case goes up to the court is you write briefs. I mean, so if they were the petitioners, they would have written the opening brief, waited for the other side to reply, and then written an answer to that. So that's the primary thing, and then you get ready for oral arguments, which is no small task if you do it right. The interesting thing I found about the advocates, particularly the advocate on the Tinker side, was relatively young and inexperienced, which in today's world would be shocking. But back then, with so many cases and before a highly professionalized Supreme Court bar, you could have somebody wet behind the ears get up and give a Supreme Court argument. And I thought he did a decent job as well.
Our last several cases had very inexperienced counsel, at least on one side, and in many cases their only case before the court, which may have been for Dan Johnston. I'm not sure what his career was after this.
Dan Johnston was wonderful, and he was not only a wonderful lawyer, but he was a very good, comforting influence in our life at that time.
He was only a year out of law school when he argued this case before the court, and he had just lost a bid to be Iowa's Attorney General to a Republican, I'm told in my notes here. We're going to listen to just a bit of the argument he made to those 9 justices.
Suppose a state passed a law applying a ban on black armbands for protest purposes across the board so that it would be applied in private schools as well. Would that be constitutional?
I think that would probably, Your Honor, interfere with some earlier decisions of this court, probably in regard to the right of individuals, of citizens, to establish private schools, and so long as they meet accreditation standards, to educate their children as they see fit. I believe that's probably a different kind of situation from what we have here. The situation here, as I view it, is based not so much upon the conduct of the students, whether or not it was permissible, but the conduct of the state, whether or not the conduct of the state was permissible. Whether or not where we have a situation of pure expression and nothing else, which, with no evidence of any material or substantial disruption of any public interest, whether or not in that situation the state can move to subordinate and to punish freedom of expression.
Attorney Jaffe, unpack that argument for us.
Well, the first part of that argument was a bit of a red herring. Could you tell private schools that you have to suppress speech? Maybe it wasn't quite as obvious then, but it is about as obvious as it gets now. That's just a non-starter. This is really a public school phenomenon because, of course, it's the state that is forbidden from restricting speech, and the place that the state has the most interest in would be public schools, not private schools. As to the private school, what I found interesting about Mr. Johnston's argument is the narrowness of it. He emphasizes again and again that this is pure speech. It doesn't involve any other activities. There's no jumping up and down. There's no protesting. There's no marching. There's no indication that it's interfering with any other aspect of school life or school discipline. And that's really what he hung his hat on throughout the entirety of the argument, is that the school had no evidence that this was a problem. But implicit in that is that if there were evidence of a problem, if there were evidence of something a little bit more, well, then maybe you can restrict it. But I think he took that tack because there was a lot of skepticism about telling school boards what they could and couldn't do. And so he wanted it to be as clean as possible and say, look, there's literally nothing here. So in that instance, at least, the First Amendment should win.
He was really basing it largely on the clear and present danger idea and also on viewpoint discrimination, and which was a winning argument.
Well, in the argument itself, they actually back off of that a little bit. So the clear and present danger standard, which is the adult version of the standard, he sort of disavows a little bit. At some point he says there should be rules for First Amendment that apply everywhere, but then he backs off and says, of course, schools might have different facts and concerns involved. And ultimately, if you see the opinion the way it came down, everyone sort of agreed that, yes, kids have First Amendment rights, but they're not quite as big as grown-ups because the schools has other concerns to worry about. But I thought he had to go there. He was getting such pushback from Justice White, for example, that in order to get Justice White to come on board, which he eventually did, I think he had to take a slightly narrower approach, which I think he did.
Yeah, and the court, in their ruling, they came up with the standard of the substantial disruption instead of the clear and present danger, which came directly from the Mississippi Freedom Summer years when students wore buttons to school and to protest the murder of Cheney, Schwerner, and Goodman. And so they were suspended for doing that, and it went to court. And right around the time that we lost at the district level in 1966, the students in Mississippi won at the appeals level in the Fifth Circuit Court of Appeals because they had not substantially disrupted school. And that was the Burnside case. So they found a way to, develop this sort of new standard, which had to do with substantial disruption for schools.
That's right. No, exactly right. The court quotes that case quite a bit. And interestingly enough, Justice White, in his concurrence, the one thing he writes in his concurrence is, while the court cites that case a lot, I don't agree with everything there. He's trying to leave himself some room for the next case where he decides maybe the school has a better point. But this case, the school really had nothing to go on.
Let's hear the argument, a bit of the argument on the other side for the Des Moines School District. The attorney's name was Alan Herrick. He was a veteran of World War II and the Korean War. He was a leader at the Methodist Church. Did your family know him?
No, I don't know. I'm not sure about that.
In downtown Des Moines. And we're going to hear part of what his oral argument was to the court for the school district.
Now, in substance, if we understand the petitioner's position in this case, it is that the school officials are powerless to act until the disruption occurs. Respondents believe that should not be the rule. Sometimes an ounce of prevention is a lot better than a pound of cure, and I think subsequent history of such activities bear out the judgment of the school officials in their discretion.
Suppose they wore a Humphrey or a Nixon or a Wallace button in the school, which might be, as was in many communities, highly controversial, in some places inflammatory.
Well,
could that be done?
I think, if the court please, if it were done as I think the record in this case shows, where they came in with a whole row of buttons on, something of that sort, that it could prove disruptive. It's a matter of dress.
Well, did they come in with a whole row of armbands?
No, but it would be any. Would there be any question if they'd walked in with a placard that said "We protest the Vietnam War"? That was.
I think there would.
Under the circumstance,
don't you think it would be different?
Normally, yes, Your Honor. But I think normally. But I say this: this thing had been extensively exploited in the press. We had a situation here where it was explosive.
So, Mr. Daffy, what do you think of that exchange?
I think it was weak, is what I think, actually. He's making a point that is often made by governments seeking to restrict speech, that we need to take a preventative measure rather than respond to an actual immediate threat. And this is a thing that comes up all the time. It comes up in Brandenburg, of course, on how much prevention can you do before the threat is certain. And he's trying to extend that role, an ounce of prevention is better than a pound of cure, and not doing a great job of it. What he probably could have done better is point out all the facts that made them think prevention was necessary. And instead he gets hung up in distinguishing between one button versus a row of buttons, an armband versus a placard. That wasn't how he was going to win this. Ultimately, if he wanted to win this, he needed to sort of say, we had good reason to believe in disruption, and he didn't quite get there.
He was talking about placards and buttons and armbands, and we have a teacher watching and says, for the benefit of AP government students, could you please explain the concept of symbolic speech and indicate how the Supreme Court has dealt with that issue?
The court has well-established, acknowledgement that symbols are speech. And this is one of the ways that we won our case, because the schools had been allowing other symbols, such as Christian crosses and even the Iron Cross, to symbolize Germany. And the school had actually allowed, not my school, but the school district had allowed black armbands as well to mourn the death of school spirit. And they had also allowed black armbands when the Birmingham children were killed. And so, yes, it was symbolic speech, but the court had recognized that, and that was well established by the time our case got to court.
Time for more phone calls. We have another family member that is joining us by phone. Leonard Tinker, still in Des Moines. Welcome to our conversation. What's your question, comment, or what would you like to tell us about?
Well, there's 2 points. Number one, the speech that Kunstler gave in Des Moines in '73, I was present there. John was not.
Okay.
And I had a chance to chat with Kunstler. Originally, Bill Kunstler offered to take the case. He was a friend of my mother's. The other thing that is of interest, when Alan Herrick was deposing my father, Leonard Tinker Jr., as part of the case, he kept referring to my dad as a commie. And Dan Johnson looked at him and he said, if you call my client a commie one more time, this deposition is over. And one of the big reasons, I think, that the Supreme Court took the case was because the Fifth Circuit had ruled that NAACP lapel buttons were protected, and in effect, the Eighth Circuit had ruled that black armbands were not. So effectively, you have a difference of opinion from the two circuits, and that probably gets the Supreme Court in there to resolve the difference of opinion.
Leonard, how old were you at the time of the case?
I was, when it happened, I was 20.
You were 20 out, and you were
in sixth.
Were you in university? Mm-hmm. And
no, I was in a small college.
And we were meeting your sister and learning about the effect the case has had on her life. What has been the impact on your life?
Well, I still get phone calls 3 or 4 times a year from kids doing term papers. It's very simple. They know it came out of Des Moines, and they know it involved Leonard Tinker. So they call Des Moines Information and ask for Leonard Tinker. Leonard Tinker Jr. is a little hard to reach by phone. They get me instead, and they will say, did you have kids who wore armbands back in the 60s? And I'll say, no, I didn't. And they'll apologize for bothering me, but I will say, but I did have a brother and sister. And a couple of years ago, a gal in St. Louis Park, Minnesota, suburb of Minneapolis, put her 8th grade daughter in a car, and they drove to Des Moines, and we spent 3 or 4 hours talking about it. And I thought, guys, we could have done this on the phone and saved 500 miles of driving.
Well, thank you very much for being part of our conversation. It's nice to meet you by phone and adding to our understanding of the case. Leonard Tinker, older brother of the defendants in this case we're talking about tonight, Tinker versus Des Moines, 1969. Next up is Nathan, Commerce, Texas, a school administrator. Welcome.
Hi. So my question comes from being a Title IX administrator, and my tension is in regards to student journalists. I want to interact with students, but my role requires that I keep confidential information privileged. I want to be able to interact and engage in good faith and trust with student journalists, but I can see headlines such as rates of rape reporting double when it increases from 2 to 4. And since building these trusting relationships is so essential, I have to have reports to do my job. How can I navigate this tension between building good faith relationships between journalists, particularly student journalists, and administrators at a school?
Well, I always advise administrators, and I speak to many administrators, and I meet so many administrators who are doing a good job of creating a good climate in the school. And as a nurse, I know that one of the healthiest things a student can do is graduate high school. And we want to have school to be a place where kids want to be. And we have huge problems with absenteeism and other problems in schools. So as an administrator, you can help your school to be a place where young people want to be, students want to be, and to promote a good climate in your school. And that means to have a respect for student voices and to have avenues where students can have their voices heard. And of course, when it comes to journalism, then we're talking about another Supreme Court case called Hazelwood. And there is a lot going on with that situation, which came after our case and then censored student journalists. However, 14 states now have passed legislation supporting student journalists, and Washington State can be proud. They were the last one just a few weeks ago that passed legislation. There's a big campaign by the Student Press Law Center called New Voices to support student journalists. So you can tell your student journalists about the campaign, the Student Press Law Center, and check them out. And I'm sure your journalists will be interested in that, and it'll be helpful to you as well.
Eric Jaffe, on that note, we have a tweet from Sarah Gonzalez. As a journalism advisor, I'm seeing more and more stories of students being censored for stories about gun safety, LBGT, drug issues. Right now, students are at wit's ends with gun safety, but they're being told by administrators, no, absolutely not. What should students do?
Well, I mean, I think students have alternative avenues to write their views and opinions. They can start a private newspaper if they want. If the question is, can I publish it in the school newspaper, you're going to have a harder time with that because the school newspapers often, though not always, treat it as part of the curriculum, depending on if you have a school that has adopted one of the policies that Mary Beth has mentioned. But there are lots of avenues for students to speak that don't necessarily depend upon the curriculum, and I would encourage anyone to try to use those avenues. Go write to your local paper. Go stand up and talk to the press. Do whatever you can, but sometimes you may have to succumb to not being able to do it in exactly this time and this place if your school is not supportive.
Well, there's a reason why the Journalism Education Association, which I believe is 5,000 journalism advisors, and also the Society of Professional Journalists have recommended that students be allowed to write in their school newspapers as long as the articles, follow good journalism, that they should not be censored for the issue that they're talking about. And they are supporting these laws in states that support student journalists now. So, yeah, there's definitely a lot going on with student journalism, and students who are interested in journalism or who want to read journalism that has to do with their lives can check into some of these campaigns.
And I don't mean to imply that I favor these restrictions. No. I'm merely pointing out that I'm no school administrator. I'm the last person you should ask whether or not this is going to help or hurt the environment of the school. If the school administrators agree that having smart journalists and training smart journalists is a good thing, absolutely, they should do that. But at some point, if they disagree, I don't feel that I'm in a position, but there are many other outlets for students as well, if you happen to be in one of those schools.
Next is a caller named Buddy in New Bedford, Massachusetts. You're on the program. Welcome.
Oh, hi. Thank you very much. And I just want to thank you all for taking this up back in 1969. I was in Vietnam during that time from September 68 to March of 1970. My question is, fast forwarding after Parkland, and you have a student who makes a concerning comment that has no action to it or nothing to that effect, and yet he is punished for the event. It wasn't criminally charged, but he was punished in the school. How do we incorporate or integrate the laws of today with what students are now faced with today and the social media, because of the social media kind of conversation before school started, on the way to school, the day after Parkland? And I can tell you that there was several cases in our area like this, but I think the student was probably excessively punished, and I couldn't see where there could be a happy medium here based on what's going on in the world today and freedom of speech.
Are you talking about comments that are threatening that students were making? Is that what you're referring to, Buddy?
Well, it was comments of frustration from a student who had been bullied and felt that something like that should happen to my school, kind of a thing. Oh boy, wow, what about us? And it was a concerning comment as it was publicized, but as concerning as it may have been, I'm just trying to see where does the limits of the individual having to say what's on his mind based on emotions that he's having, and not really being a violent person, but feelings that he's talking out loud and whatever, and doing it on Instagram using social media, but yet he was punished at school because of it.
Well, all of those kinds of comments need to be taken very seriously and followed up, and that's why we need more school counselors and more school psychologists and more school nurses. I don't think that punishment is always the solution either, because that can backfire and not necessarily lead to students having the kind of behavior that we want to see.
Isla is in West Bloomfield, Michigan. You're on the air.
Yes. My question is this. How does Tinker apply to the young man who refused to salute the flag? He did not interfere at the football game. He made no sound. And is that not an example of symbolic speech? Also, this has trickled down to colleges and to high schools. I think that it's unfortunate that people don't remember that the United States Constitution is the supreme law of the land, and it should certainly be applicable to the schools. I do not think that any group of people, even though we hold our administrators and teachers responsible for our children in loco parentis, that these kinds of things should be limited because they may be controversial, as we're talking about students being able to publish things in newspapers about gun control and things that might be controversial. Now, we want our children to be able to, as Jefferson said, it's necessary for an educated populace to build a democracy. And certainly if we're going to repress these kinds of thoughts that are outside of the parameters of what most people think in children, how can we expect them to develop?
Well,
thank you very much.
Excuse me, I'm so glad you said the word controversy, because that's what it's all about. And we have to help students to find ways to talk about controversial issues and not just sweep them under the rug, but to talk about things with respect with each other. And luckily, that's what we have, is a First Amendment to guide us in doing that. In our democracy, we believe that all viewpoints and everyone should be respected and should be listened to. As far as kneeling for the flag salute, that's clear under Barnett in 1943, that you cannot force. That had to do with forcing students to speak, not allowing free speech. It had to do with allowing students not to speak. And that says that you cannot force students to speak. And under that ruling, Justice Robert Jackson gave one of the most beautiful comments about what education should be and that what democracy should be, saying that if there is any fixed star in our constellation of democracy, it is that no official, petty or high, can say what is orthodox in matters of nationalism or politics or religion. And that the schools are educating young minds for democracy is a reason why they should be very scrupulous in standing up for the freedom to express themselves.
We have a half an hour left to go in our discussion of the 1969 Tinker versus Des Moines. The decision came out on February 24th, 1969. The CBS folks in the news department have been very generous in opening up their archives to us for this series. So we're going to listen as Walter Cronkite announces the Tinker decision on the evening news.
The Supreme Court today endorsed the right of student protest so long as the protest does not disrupt order or interfere with the rights of others. But a dissenting justice, Hugo Black, said the ruling begins a revolutionary era of permissiveness fostered by the judiciary. The 7-2 decision upheld the right of 3 Des Moines teenagers to wear black anti-war armbands to high school. The court said students do not leave their freedoms of speech and expression at the school door.
Well, that's one way that the country found out about the decision. How did your family find out about it?
I think someone called my school and I came home and I didn't have any idea how important this ruling was going to be, either for my life or for the country. It took many years till it really, hit me how important it was. One of the first times was when I was in nursing school some years later, and the case was in my nursing school book.
How about the school? How were they treating you and your siblings at that point? Were they watching this with interest?
Strangely enough, at my new school, it was pretty much ignored, even when we won the case. And I've thought about it later, thinking that the social studies teacher or someone might have said, hey, something kind of interesting happened to Mary Beth yesterday. But I think they just didn't know what to make of it, and so it was pretty much ignored.
This is the majority of that formed the 7 in the case, written by Justice Fortas, as we said, the Chief Justice Earl Warren, joined by Douglas, Brennan, White, and Marshall, with 2 concurrences, Stewart and White. And then there were 2 dissents, as we heard. They were Justices Black and Justice Harlan. Here's an excerpt from the majority opinion by Abe Fortas. In our system, state-operated schools may not be enclaves of totalitarianism. School officials do not possess absolute authority over their students. Students in school as well as out of school are persons under our Constitution. They are possessed of fundamental rights which the state must respect, just as they themselves must respect their obligation to the state to the state. In our system, students may not be regarded as closed-circuit recipients of only that which the state chooses to communicate. They may not be confined to the expression of those sentiments that are officially approved. In the absence of a specific showing of constitutionally valid reasons to regulate their speech, students are entitled to freedom of expression in their views. What strikes me is the declaration that students are persons under the Constitution.
They are persons. I don't think there's a lot of debate about that, though remember, the First Amendment doesn't talk about persons. It just says Congress shall make no law abridging the freedom of speech. Now, if you think that's incorporated wholesale into the 14th Amendment, it may not matter if they're persons. It's about what Congress or what states do in some instances. What I find fascinating about the Tinker opinion is that the language is glorious. The language is lofty and beautiful, and it's a paean to sort of what I think are some of the essential aspects of democracy in America. The actual holding is nothing like that. The actual holding is a pale shadow of that lovely language because they put so many qualifiers on it. They put the qualifier on it that it was pure speech, but if it wasn't pure speech, maybe this isn't true. They put the qualifier on it that there was no evidence of disruption, but if there was some evidence of disruption, maybe it's not true. They even went so far as to imply that a viewpoint, a particular viewpoint, might be restricted if there was evidence that it would cause disruption. So what I love about the opinion, and what I think is lasting about the opinion, is that everyone cites this opinion because it so beautifully articulates what we think the First Amendment is about. But when push comes to shove, it didn't really go that far.
It also articulates what education should be in democracy, where it should not just be a one-way interchange between, with the teachers just, pouring information into the students. The students have something to say too, and students should have some input too, and that they should not be in enclave of totalitarianism, the schools. But it is a fairly tame ruling because as soon as there's, and it does say substantial and material disruption. Like I had a situation where a student was wearing a Black Lives Matter shirt to school. This was in Arizona. And so the administration was saying, well, there had been an argument between her and another student a few days earlier. Well, that's not a substantial disruption, and it is supposed to be a substantial disruption. But it's fairly tame because as soon as the school can use the ruling actually at times against students also,
often,
and they
yes.
do all the time, saying that it's causes substantial disruption, and it also pretty much, prior review comes in there because if you can predict
That's right.
disruption now with the Tinker ruling, it's also something that the,
things you could never do with grown-ups, to restrict grown-up speech outside of the school context, you can do based upon some of the qualifiers in Tinker. Like I said, though, this gets cited all the time, not for the qualifiers usually, but for the higher principles and the loftier principles.
I'm going to jump in because our time is growing short, unfortunately. To the Black dissent, one personal note about Justice Black is that he had a personal story in his family going on as this case was happening. His grandson, Sterling Black Jr., had been suspended shortly after the oral argument for publishing an underground newspaper critical of his school's administration, and Justice Black supported that suspension. In his dissent, here's some of what he wrote. It is nothing but wishful thinking to imagine that young, immature students will not soon believe it is their right to control the schools, rather than the right of the states to collect the taxes, to hire the teachers for the benefit of the pupils. This case, therefore, wholly without constitutional reasons, in my judgment, subjects all the public schools in the country to the whims and caprices of their loudest mouth, but maybe not their brightest students. Your reaction?
It's quite disrespectful, it sounds to me, towards many students who he's calling loudmouth, and his predictions did not come true because he was saying that there was going to be lie-ins and sit-ins and a revolution of student voices. Unfortunately, sort of the opposite happened. There were more lawsuits after the Tinker case having to do with, say, hair length and some speech issues, but there were 3 subsequent cases after Tinker that weakened the ruling as well. So what he predicted and worried about certainly did not happen.
We'll have a chance to talk to about those cases before we finish. But here is a headline on that dissent, an angry dissent on armbands. Is there anything from a legal standpoint lasting about his Justice Black's dissent?
You know, at the end of the day, the concerns he raised, I think, are partly responsible for why you see a backtracking in later cases. And that perhaps is why you see cases about student newspapers, cases about sexual innuendo, other kinds of cases where the court sides with the school rather than the student. In part because of some of the concerns about maintaining discipline in the specialized context of a school.
And also because the court changed. And the people who were on the court changed radically.
Well, but even for some of the people who who were on the First Amendment side of Tinker, I think backed off some of it. And you can even see with Justice White and Justice Stewart, they're rather hesitant about, Justice Stewart particularly in his concurrence, is rather hesitant about extending the full panoply of First Amendment rights to students. And you see concerns like that with Justice Roberts. Justice Thomas relatively recently, has largely endorsed the Justice Black view. And so you see some folks retrenching. So on other First Amendment issues, he's incredibly pro-First Amendment.
We're getting a few questions on Twitter about applications. Here's one of them. F.J. Darnell asks, could this ruling be applied to military schools? And then there's another one that asks, does it apply to universities?
Well, on military schools, if by that he means West Point or government-run military schools.
I would imagine under high school.
Well, many military schools are not run by the government; they're private military schools, and so in that context, of course, there are no First Amendment rights at a private school. But if it were a government-sponsored school or a state-sponsored school, for example, it would apply, but it would apply differently because what would disrupt discipline in the military context might be very different than what would disrupt discipline in the civilian context.
But it is related, actually, the military speech rights to students' speech rights and the disruption standard. And
yes, I think the standard would apply. The outcomes and the factors that got weighed in that standard might well end up being different because of the type of discipline you're trying to teach.
I'm going to go back to calls, then we'll listen to John Tinker once again on what happened to him and his life after this case and some of his thoughts on the legacy. Marcello, New York City. Welcome.
Hi, congrats. This is a great program. I just wanted to know why Justice Black, who is considered a First Amendment absolutist, why did he dissent in this case?
I had a sixth grader ask me that same question not too long ago who's doing a History Day project, so maybe you can...
Sure. So Justice Black actually gives some explanation of this. While he is quite absolutist about what the words "Congress shall make no law" mean, and it was very strict about that and didn't like balancing tests and didn't either no law or yes law. He was also very reticent to have the court inject itself into inherently legislative, so social balancing questions. And here he thought the court has no expertise on what does or doesn't maintain discipline, and so to have judges, unelected judges, making those calls instead of school boards and states, he was very reluctant to go there. In addition, he points out in his dissent that he always thought that while you have a right to speak, you don't have a right to speak any place at any time you want. You can't march into a church and denounce Catholics. You can't march into a Jewish temple and denounce Jews. And you can't march into a school and do something other than your algebra class, was his view.
Christine in McLean, Virginia. You're on the air.
Hi. What do you think of the lawsuit by Julie Brinksman, who gave the middle finger to President Trump's motorcade while she was bicycling alongside of it? She lost her job due to her action. Now she's suing her employer for wrongful termination, claiming political speech. What do you think the outcome will be?
Unless her employer is a government agency, I think the outcome is likely to be that she'll lose unless there's something in her contract that somehow protected her. But as a constitutional matter, it's almost a non-starter. Unless it was a government that she worked for, and I don't recall the facts of the case well enough to recall who her employer was.
Jan is in Nashville, Tennessee. I don't want to get off on a tangent on that case, for we have so little time. Jan, Nashville, Tennessee.
Good evening. I just wanted to call in and thank you for covering this way back when. My best friend and I organized armbands to protest the Vietnam War, try to bring these soldiers home in, I believe it was the spring of 1970, and the school administrators threatened everybody who was wearing one with suspension. At the end of the day, my friend and I went to the library, and we were able to find the then recent determination by the court, and I was pleased to see you play the Walter Cronkite clip, because we quoted that in the city's largest newspaper that said that the court determined that students should not be required to leave their opinions at the schoolhouse door. After graduation, I had several teachers approach me and say that they agreed. Of course, they were in peril of their jobs if they'd said anything. But I'm fascinated to hear this case being discussed from the perspective of history.
That's great that you were able to use it to do something, because we were talking about how in some ways the ruling can even be used against students, but it did change the power structure in schools, I think, and I've talked to many educators who agree with this, that the power dynamics changed. Because before then it was up to the principals and the school boards what was said in the schools, and after this, administrators were put on notice that students did have a say in the schools as well.
We're going to listen to John Tinker talking about the decision and its impact on him and on the legacy of this decision in his life.
To be associated, really humbled by the success of the case and what that's meant to student expression in the United States since then, and to have my name associated with that case, it's really a humbling experience. And then personally, it's been a very enriching experience for me, because I'm invited to talk to student groups, and I speak regularly to postgraduate classes of prospective principals and administrators and teachers. And what an honor. I mean, it's a wonderful thing for me personally, but I also think that it's a very good thing for our society to realize that students in school are learning how we have a democracy, how we make it work. And we make it work to the extent that it works by talking about things.
Well, speaking of talking about things, on the phone with us right now is Stephanie Wager. She is a social studies consultant for the Iowa Department of Education. Formerly was a teacher at Roosevelt High School in Des Moines, which was Christopher Eckert's, one of the defendants in the case, school. And her husband taught at Harding Middle School, which was Mary Beth Tinker's case. Stephanie Wager, we heard from Mary Beth Tinker that the day the case was decided, her teacher didn't incorporate it into a learning experience. What is the Tinker case like for students in your school district now?
Yeah, well, I think if I were to sum it up, I would say that Iowa teachers really think about the Tinker case from a very personal level. Either they really talk about it because it has such a powerful impact on sort of Iowa history and local history, and they can talk about it as being proud of that event happening in Iowa. But they also, most of them have had an opportunity to meet Mary Beth or John or somebody else involved in the case, and I think that really makes it so much more personal. When Mary Beth can share the context of growing up in Iowa, the context of what her family went through, just the context of the time period, I think that really makes it such a more personal case for Iowa teachers to talk about and cover.
And in this particular time period, when students seem to be getting more active as speakers, what are you finding in the discussion in schools and between students and their teachers about their right to speak up?
Yeah, well, I think that most teachers in Iowa and really across the country, they use this case as really the legacy case, connecting it from 50 years ago to today, and you can still see patterns of students speaking up today, and they really constantly refer back to the Tinker case. I hear this so much from Iowa teachers as sort of the bedrock case for explaining to students and making sure that they understand the impact of informed actions in today's schools.
Great. Thank you very much for being part of our discussion tonight. Interesting to hear how it's taught when it's a local history story. Mary Beth Tinker, what about your relationship with the Des Moines School Board over the years?
Yes, it's been very good. The superintendent of schools, Tom Ahart, helped me to plan a big anniversary there a few years ago for the 50th anniversary of being suspended. And my brother, John, and unfortunately Chris Eckhart died, so he wasn't able to be part of it. But Bruce Clark came, and my brother and sister Hope and Paul came, and we went to the elementary schools, 5 high schools. We went back to my middle school where they dedicated a locker to me. And so now the superintendent, Mr. Ahart, we're planning a celebration for the 50th anniversary of the ruling as well. And he has a great admiration for the ruling and for student voices in general. And so he's a fan of the case.
We have some video of a Mary Beth Tinker mural. Where is that?
That's at my old junior high school, also at Warren Harding Junior High School, because they have an arts theme there, and it's really been great to be involved with them.
Did you ever get, or did you ever expect an apology from the school board?
No, there was no apology, but the Roosevelt students all voted the year that we won to have Dan Johnston, our lawyer, to be the graduation speaker, and he was.
How does this all feel to you, seeing your picture on a wall at the school where you attended?
The whole story has been really crazy, quite a journey, and very, very unexpected. And as I tell students, this really is how most history is made, by the small things that we do in life. And so then you have to take your experiences and find what you can do with them to make a better world. And I've found that I can share this story with students and help encourage them now to speak up for the things that affect their lives.
We have about 8 minutes left, and there's been reference by both of you to later First Amendment decisions that have affected schools. I'm going to put them on the screen and have you, Mr. Jaffe, tell us a little bit more about them. They include Bethel School District versus Fraser in 1986, Giles versus Marino in 2007, and Morse v. Frederick in 2007. Those are just case names to all of us watching it. What do they mean to this issue?
So both Bethel and Morse are cases that sort of pulled back a little bit from sort of the lofty aspirations of Tinker, the bigger language. In fact, in Bethel, the issue was a speech at a school assembly that had a lot of sexual innuendo. And the court pretty solidly came down in favor of the school, which punished the student for having given this sort of a speech. And the language difference in that case is striking. They talk about the school being a place to inculcate values of civility, to teach students what to do, even on personal sensibilities. And while we would all like to be more civil to each other, it's quite different from the notion of it's not a totalitarian society telling kids what to do. Here, the public school system is actually teaching kids, and it treats kids less as rational actors and more as clay that needs to be molded to become citizens. What the best line from that thing is that while kids may be able to wear Tinker's armband, they can't wear Cohen's jacket. And Cohen's jacket is the jacket that said F the draft. They wouldn't be allowed to wear that in school. Vulgarity, obscenity, sexual innuendo, not allowed. Giles v. Marino is actually a Second Circuit case. What's notable about it is Justice Sotomayor was on the panel. And in that case, the student wore a T-shirt criticizing President Bush and the war, the younger Bush, calling him a chicken hawk and making references to drugs and alcohol. And he was told to cover up the references to drugs and alcohol because it violated the drugs and alcohol policy. The Second Circuit said it was okay to wear that shirt because he was against drugs and alcohol, not for them. And what could possibly be the school's interest in somebody criticizing drug and alcohol use? And then that brings us to the last case you mentioned, which is Morse v. Frederick, where a young comedian in Alaska, when the Olympic torch is running by, the school is let out, and it's sort of like a school field trip to wave at the torchbearers. He unfurls a flag that says "Bong hits for Jesus," and the school punishes him, and the court upholds that because they say it could be fairly interpreted as advocating drug use. So there are two big exceptions now to Tinker. One is sexual activity, and the other is advocating illegal activities. Whereas in the case in the middle, the Giles v. Marino, he's opposing illegal activities, and so that one was okay.
And how do you process these erosions or walkbacks from the Tinker decision?
Well, probably the most important one of the cases is the Hazelwood case in 1988 that had to do with student journalism, and it also talked about student-sponsored speech. So unless the school is established as a public forum or the newspaper is established as a public forum, or unless the student lives in one of those 14 states where legislation has been passed to bypass basically the Hazelwood decision, it has the most impact on students. But the Tinker ruling also said that neither teachers or students leave their right to expression at the schoolhouse gate. And so teachers' rights and students' rights are very much tied up together. And when it's not a good time for teachers' rights, it's usually not a good time for students' rights. And that would be now. It's not really a good time for students' rights because of all of these cutbacks in rights and in cases that have limited the Tinker ruling. And also there have been cases that have limited teachers' rights as well.
Sandra is in Tama, Iowa. Welcome to our conversation.
Hello.
Go ahead with your question,
Sandra
please.
McLaughlin.
Sure.
Hi, this is Sandra McLaughlin. I'm in Solon, Iowa. I was in ninth grade when the Supreme Court ruled on the Tinker case, and although I thought our whole class was going to be wearing black armbands that day, only 3 of us did, but we were told clearly when the ruling came down, if it was adverse to us, we'd be kicked out of school. But we had a lot of discussion that came out of what was happening in Des Moines, and I just wanted to share that with you. 5 of us out of a class of about 85 ended up being attorneys. I want you to know what kind of an impact you had, because it really did have significant impact. My son is an attorney as well and is very much involved in politics and the law. And my daughter is a journalist at the New York Times.
Well, that's
So you
great.
never
That's
know.
great. It's great. We inspired some attorneys, and I think that's great. Thanks for calling. And I think we've also inspired some students who, even though it may not be a great time for standing for students' rights, students are using their rights very much today, and it's very heartening to see. Thank you.
Well, let's talk about that because in the past 2 months there have been national walkouts. The most recent one just last Friday. Here's a couple of headlines. Texas School District threatens to suspend students who take part in gun walkouts. New York Post on March 14th, school to suspend students who walked out for gun protest. And there are similar ones in other parts of the country. Ian Zollinger asks us on Twitter, do you think the recent walkouts would qualify as protected speech under the Tinker test as they cause lessons to be disrupted and classes canceled?
I think as long as the school rules are not focused on one viewpoint or the other and are fairly clear that, no, of course they're disruptive if you're walking out. The consequences may be exaggerated, but you're not going to class, you get an absence. It may be nothing more than that. If they tried to punish them for the particular viewpoint or punish them beyond what the normal policy for an absence would be, then there might raise some questions. I want to point out, by the way, that this cuts both ways. There are cases in New Jersey now of kids wearing Second Amendment shirts who are getting punished for referring to guns. Sure. And so the Tinker legacy cuts both ways on this gun battle, and those fights are still being had. Obviously, I think if a kid comes to school and says, March for Life on their shirt, that seems like a pretty straightforward Tinker case to me.
Yeah, and also students that are speaking up now with these walkouts and rallies, and it's so great, so heartening for me to see as a trauma nurse. I've worked many years with children that have been shot, but I think we should also remember that the students are really trying to keep disruption from happening in their schools by taking a stand and by having the rallies and the walkouts today. They're trying to keep some stability going in their schools where they don't have shootouts going on in their schools, and I admire them for that.
So I'm pretty sure that's not the disruption Tinker was thinking of, but yes, student activism of whatever flavor, on whichever side of the issue they come down on, I think we should always encourage.
As we close here, since we talked about symbolic speech, you can answer the question one Twitter follower had, what's your orange ribbon?
Oh, the orange ribbon is to memorialize the students who have been shot. And as we know, so many of them aren't shot in school, but out in the community. And I really admire the way that students have reached across racial, boundaries to unite together, because so many of the students have been shot out in the community. And so that's what the orange ribbon is for. And my pin is Thurgood Marshall, who's a hero of mine, who was the attorney with the Brown decision, of course. And his wife gave me a pin with his picture on it, so I like to wear it when I'm speaking to students to remind them that he is with us in spirit, and he wants students to have their rights and use them.
A couple of things to tell you as we close here. C-SPAN has a book available. You can find it on our website, cspan.org/landmarkcases. with case summaries of the 12 cases that we're featuring in the series this year. Still a few more to go if you're interested in some background. And also special thanks as we close out here to the National Constitution Center in Philadelphia, which has been our partner in this and our first installment of Landmark Cases. Mr. Jaffe, thanks so much for bringing your legal expertise to this conversation. And Mary Beth Tinker, so interesting to have someone who was personally involved in one of our cases at the table.
Thank you. It was great to be here. Thank you.
Thanks for watching. You have a good night.